Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is going to be a quick update for my brothers and sisters down there in the great state of Oregon. But as we know today, December 13th was a huge day in the battle to preserve Oregonians' Second Amendment rights and to stop the implementation of Ballot Measure 114. Now, there was a huge hearing today down in Harney County. We're going to talk about that in a few minutes because I spent part of today geeking out and watching that hearing from afar. So today, let's spend a few very important minutes and talk about huge updates from Oregon on Ballot Measure 114. Okay, so the issue we're talking about, just trying to get everybody up to speed on everything, is what happened today down in Oregon, particularly in Harney County, as it relates to the implementation of Ballot Measure 114. As we know, there was a show cause hearing. Started at 9 a.m. this morning. It went all day before the Honorable Robert Ratio. Now, I also hear that the last name may be pronounced Ratio, and to his honor, I apologize if I have mispronounced the name. However, he ran an excellent hearing, and I did have an opportunity to kind of log in and log out as I went through my day of trying to run a law practice and also geek out on an Oregon hearing from afar. But the good news is that our resident man on the scene, that's right, the Oregon Second Amendment warrior himself, Jerome, well, he was logged in the entire time, okay? Every time I logged in, I found Jerome on there. And yes, he was able to not only feed me information about stuff that I'd missed, but Jerome was kind enough to send us some written updates about what happened. So I'm going to get all of you in Oregon up to speed on what happened. But remember, this is all compliments of warrior on your behalf, Jerome. Okay, now as we know, there are several challenges to this horrible piece of legislation, and there are several components that are at various stages of what's being argued and what's being stayed and what's enjoined and all of that. So let's get you all up to speed, because as we started today, all of Ballot Measure 114 was currently enjoined. That is, the state was on pause now and could not enforce any portions of Ballot Measure 114. As of the taping of this video in the evening of December 13th, that is still the case. All portions of this injunction remain in place. Now let's break it down for you component by component. Okay, number one, the permit to purchase, or what I like to call pre-purchase permitting, okay, which is, in my opinion, the most offensive, constitutionally invasive portion of this entire measure. That remains enjoined. There was no arguments taken on that. The state was told today that the judge's injunction enjoins the enforcement of the law. It does not enjoin the state from preparation to implement the law. So we encourage them to continue to work on implementing the licensing measure. The state seems to think that they're going to have this done in the next 30 to 60 days. No way in hell is that going to happen. But the judge says that once the framework is in place, a hearing will be set within 10 days to determine whether or not the injunction would be lifted on that portion of Ballot Measure 114. Now understand, even if the state gets all of the framework in place for this unconstitutional licensing scheme, Judge Ratio could still decide to enjoin the state and say it doesn't matter what framework you've done, you still have a massive constitutional problem with this, which candidly, I believe, is exactly the case. Now, the other portion is closing the Charleston loophole, the 3-day loophole, and all this other stuff related to background checks. What the judge has done is set a new hearing on that component of Ballot Measure 114, and that now is set for December 23rd at 9 a.m. So all the parties are going to have to be back before Judge Ratio on December 23rd to argue whether or not the injunction should remain in effect on that portion of Ballot Measure 114. Okay, and then the one component that really has most of your interest down there is this magazine ban. Now, that was enjoined on December 8th by Judge Ratio, and that injunction remains in place as we tape this video right now. Now, here's the important thing. Both sides got to make arguments today. Both sides got to present evidence today. Both sides had witnesses that testified for them and did arguments about this particular part of the injunction. The judge has ordered that both parties have until December 17th to file any supplemental memorandum. So any other additional arguments, memorandum of authorities, exhibits, things like that, they have until December 17th. The record then closes. At that point, Judge Ratio announced to the court that he will announce a ruling on the injunction on the magazine ban on January 3rd, 2023 before 5 p.m. So that is a date for all of you to circle, January 3rd, 2023 before 5 p.m. So that is your up-to-the-minute updates, compliments of Jerome down there in Oregon. Now, I had an opportunity to geek out and not only listen to the arguments, but I had an opportunity to watch a lot of the comments that were going on in the chat section, and some of them were quite colorful. There was a lot of concern that plaintiff's counsel was not very exciting, not very energetic, not as articulate as people may have wanted them to be. I want to caution everyone and throw a little shade on that observation for one reason here, is that, yeah, really snappy one-liners, very emotionally powerful arguments play very, very well in front of juries, okay? But this was an argument that was being made in front of a judge who it was obvious to me, he's been on the bench for a long time. This judge knows the law. He knows the rules of evidence. He doesn't need all the icing on the cake. He doesn't need the sugar sprinkled on top. He wants to know what the facts of the case are. He wants to know what the applicable law is. So when you are armchair quarterbacking a bench trial, yeah, if you're really looking for a lot of fireworks and things like that that make for great television, you're not going to typically find those in bench trials. You will find those more frequently in jury trials. From my perspective as an attorney who's actually spent the last 22 years in a courtroom arguing in front of juries, that while I don't necessarily disagree with the lack of excitement in the presentation on plaintiff's counsel, there is zero doubt that plaintiff's counsel was well-versed in the law, well-versed in the industry of firearms, and well-researched and prepared to make the arguments today. I thought all the points that needed to be made were effectively made. I thought all the arguments were effectively made. I thought the evidence was presented in a fashion that is most favorable to the plaintiff. So kudos to the attorneys from Gun Owners of America for doing that. Listen, in the meantime, I know a lot of you are going to have more questions about Ballot Measure 114 or anything else that may be left of our Second Amendment rights. So if you do, remember the drill now. You can contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. In the meantime, let's remember now, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.